We are live and on the record.
All right, we resume our argument session this morning with the remote hearing portion of it. We have two cases remaining for argument. The first is a matter involving parental rights, case number 2020P1302. I've reminded counsel that the case is impounded and admonished them to refrain from reference to any of the impounded material. With that, counsel for the mother, you may begin.
Thank you. Good afternoon, Your Honors. May it please the court. I represent the mother in this matter who will be watching the argument today.
And if you might mute yourselves if you're not presenting, that would be helpful. Thank you, Attorney Sullivan and Attorney Houlihan.
I apologize.
It is incumbent upon a court in a child custody matter to properly exercise its jurisdiction, and if properly exercised, only admit evidence in conformity with the rules of evidence. The requirements are heightened when the constitutional rights of a parent to the care and custody of her child are implicated in a termination proceeding. In this case, the juvenile court improperly exercised its jurisdiction when it scheduled and conducted a trial and then issued a decree terminating mother's parental rights. The court further committed error of law in its findings which relate to jurisdictional issues such as the mother and the child's residence, and incorporating opinions in 51A reports substantively rather than solely for setting the stage to explain how the case became or how the case came before the court and were in fact incorporated for the truth of the matter. These errors require this court's vacating of the decree.
Attorney Remillard, before we get too far into the discussion, maybe you can help me out. Is the question of home state jurisdiction a question of subject matter jurisdiction or personal jurisdiction?
It's subject matter jurisdiction, Your Honor. And I would, so under 209B section 2, that's subject matter jurisdiction. And under that statute, jurisdiction in Massachusetts cannot be exercised if another state is the child's home state.
I understand. I've not gone back to look at section 2 of the statute. You're telling me that that statement of subject matter jurisdiction is explicitly laid out in the statute?
It's the language of the statute. It says any court which is competent to decide child custody matters has jurisdiction to make a custody determination by initial or modification judgment if, and then one of the provisions that I'm contesting is with respect to home state. So if the statute, the language of the statute indicates that the court may make a custody determination, while it doesn't specifically say subject matter jurisdiction, I believe that that's the intent. Further,
I get it. Well, let's proceed on the assumption and understanding that it is subject matter jurisdiction. And if you would then just address the arguments that the department has made about the suggestion that there is no state that has home state jurisdiction in this matter.
Your Honor, I certainly would not concede that issue because with respect to, we have this case that I cited in my brief, guardianship of Zeke. Even though in that SJC case, even though no parent resided in that state at the time of the filing, the SJC found that that state, Texas in this case, had home state jurisdiction, and the SJC found that Massachusetts did not have jurisdiction to issue a custody determination. So
but in this case, the parties were in Massachusetts. All parties were in Massachusetts at the initiation of the case. Isn't that correct?
That is correct at the initiation of the case, but there was also a prior case in New Hampshire and that had been filed in July, June or July, I believe, I'm sorry, July of 2018. This matter was filed in September of 2018.
Why
And
isn't
at
this
that
case
time,
closed?
all the parties were in Massachusetts.
I'm sorry?
And at that time, all the parties were in Massachusetts, correct?
No, as far as the New Hampshire proceeding, no. As of that time, mother was in New Hampshire, the child was in New Hampshire. And in fact, in DCF's own records indicate that mother moved to Massachusetts in August of 2018 when she stayed on the couch of her friend David's home. And I believe that is at, sorry, I'll provide the site after, but there was an open New Hampshire case in the beginning of August of 2018. Mother moved to Massachusetts only after New Hampshire closed that case, presumably because they had no protective concerns.
But the presence of that prior action does not, under the criteria, establish New Hampshire as the home state. Correct?
The fact that there was a prior action, it does not definitively establish that New Hampshire was the home state.
It doesn't definitively or otherwise establish. It is not a determinant of home state status. And the New Hampshire case, as you've just described, was no longer open or pending at the time that the parties present in Massachusetts were brought subject to the juvenile court.
I don't think that the record is fully clear as far as it was no longer pending. What the record shows is that there was an ex parte motion in which custody of the child was granted to a third party through the New Hampshire court. At the return date, the week after, when mother was able to appear, the judge granted mother custody. I don't know.
If the record is not clear, is this a matter that requires us to remand it back for findings?
I do think that there needs to be clearer findings with respect to the jurisdictional issues, because I certainly recognize that this was not raised in the trial court, but in subject matter jurisdiction certainly can be raised at any time. And if there's a question,
can be. Subject matter jurisdiction can be raised at any time, but the fact that it wasn't raised below, the mere fact that there was a prior action, and you could certainly submit to us court records showing that the case was open at the time, and then make argument that the presence of an open case forecloses home state jurisdiction in the circumstances here where the criteria otherwise would appear to be present. But I don't recall seeing any argument that an open case in another jurisdiction forecloses home state jurisdiction. And that may well be, I can imagine that being a sensible outcome, but you haven't made that argument even now, and we don't know that it's open.
We don't know whether or not it's open, but if it was open, then we have a prior pendency action, which would have absolutely prohibited Massachusetts from exercising jurisdiction for anything other than emergency jurisdiction. And
all right, does this case fall in the emergency category?
Because the child was present in Massachusetts, and DCF took, I believe that DCF took emergency custody at that time. So I do believe that the court would have had the authority to issue an order under its emergency jurisdiction. However, once that emergency is expired, the court doesn't have any right to schedule a trial or have a hearing on the merits with respect to this matter, because the emergency jurisdiction is very finite.
Attorney Remillard, bear with me for a moment, but maybe I'm just not on top of the materials in this case, but I don't recall any argument in your brief that that the jurisdictional defect was attributable to a prior pending action that was open in New Hampshire. Did you make that argument to us?
I made the argument that the New Hampshire action was the first action in time and that there were these orders. I did not specifically
Not make any argument that that it was open, or that the fact that it was open would preclude jurisdiction in Massachusetts, and there is no record support to suggest that it was in fact open. I guess I'm having difficulty understanding how we should take up a foundational argument. I mean, we can talk about the fact that they first asserted jurisdiction as a separate legal argument and engage that question, but trying to carry us at oral argument to an entirely separate argument for which there's no record support is a bit of a heavy lift.
There's no, frankly, Your Honor, there's no record support for either position, whether it's open or whether it's closed. That record support isn't there because the jurisdictional issue was not raised at the trial court. Certainly, Your Honor, I will concede that I did not specifically raise in my brief that, you know, there may be a prior pending and prior action that remains open. I would concede that, but where Massachusetts is a second court called upon to make a custody decision, particularly where it's less than about I believe it's a month and a half, and I apologize if I don't have my dates all there, about a month and a half after the New Hampshire makes a decision and the court is aware of it, I think that that inquiry needs to be made. That inquiry needs to be made as far as where was mother living? Was New Hampshire the home state, which I argue that New Hampshire was the home state for this child.
We can engage the question of whether New Hampshire was the home state or not. Certainly, but if the New Hampshire case, the mere fact that a case had opened and was no longer pending does not, under the home state criteria, establish a foreign state as the home state, or foreclose a state to which the parent and child relocate from asserting jurisdiction if they are present at the time of commencement of the proceeding. So where we are left is your suggestion that the possibility that a prior action remained pending at the time this one did, which was never explored below and what wasn't raised in your argument, is a reason that we should somehow disturb the decree.
Was that a specific question? I apologize. Were you asking me a specific question? I'm sorry.
I was making a statement more than asking a question. I was suggesting that I don't understand how you can be asking us to vacate the decree or remand for further proceedings on something that rests on an argument that wasn't raised in your brief and a speculative foundation.
Your Honor, I believe that the vacating of the decree should occur because there was the issue in New Hampshire was the home state of the child. We
can certainly talk about that, but I'm just trying to get after the suggestion that the New Hampshire proceeding remained open. I don't see how we can undertake that argument in this proceeding.
I believe, okay, Your Honor. I believe that I was responding to a inquiry directly with respect to the New Hampshire proceedings. But with respect to the argument that Massachusetts was not the child's home state. The filing of the petition in New Hampshire was. One, we have the prior pending act or prior action, whatever it may be in New Hampshire. Certainly, New Hampshire would have had to make a determination that they had jurisdiction of some sort. And under our statute, a child's home state is the state in which a child resided with his parent for at least 6 months, and if less than 6 months, I just
you can finish out that statement. I realize that we've consumed a large portion of your argument on a collateral issue, but that, in fairness, that was something that really caught us completely off guard.
And if the child lived there less than 6 months, the home state is the state in which the child lived from birth to and lived in since birth. So that certainly could have been a reason for New Hampshire to take jurisdiction. The child was born in New Hampshire on January 19th, 2018. The court found that the mother and the child lived with the mother in New Hampshire at the time of birth until he was about 2 months old, and that's finding of fact 54. Then the mother and child moved between Nashua and Manchester, which was also the same finding of fact 54. And mother had involvement with New Hampshire DCYF at various stages, commencing after the child's birth until they closed her case on August 7th of 2018, stating no protective concerns. In page 19 of the record, it was shown that mother moved to Massachusetts in August of 2018. So we have 6 months there of the child's living there. Any indication in the record that mother moved between Massachusetts and New Hampshire during that time was through 51A reports that the court indicated were admitted not for the fact of the matter or the truth of the matter asserted. They were admitted with respect to show to set the stage to show how the case came before the court. I do recognize that my time's expired. I would be happy to rest on my brief unless anyone in the panel has a question.
We do have these arguments very well fleshed out. Your brief was quite thorough, and we appreciate that. So, so we will take up those questions based on your presentation and your brief. And I thank you for your presentation.
Thank you, Your Honor.
Mr. Houlihan, will you be going first? You may begin.
I will, Your Honor. Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. My name is Michael Houlihan. I'll be arguing on behalf of the Department of Children and Families as appellee. I want to also begin by addressing the question of jurisdiction. As set forth in the department's brief, we believe that jurisdiction was proper under 2 prongs of the MCCJA, namely the default and emergency jurisdiction prongs. Turning first to default jurisdiction, the record clearly supports all of the requirements of that section. First, as detailed in the department's brief, the child had no home state at the time these proceedings commenced. No later than August of 2018, mother and child had relocated to Massachusetts. Thus, there was no state in which child and any parent had continuously resided for at least 6 months immediately prior to the proceedings. Second, it was clearly in the child's best interest for the Commonwealth to take jurisdiction over the matter. Within the meaning of that section, the best interest standard turns on whether the parents and child have a significant connection to the Commonwealth and whether there is substantial evidence concerning child's present or future care, protection, or personal relationships available in the state. In this case, the record demonstrates facts sufficient to demonstrate both prongs of the test. Mother and father both enjoyed substantial connections to Massachusetts, including their previous residence together and education in Lowell, and child both resided and received medical care in the Commonwealth prior to the initial custody proceeding. In the alternative, the emergency jurisdiction provision likewise supports the court's jurisdiction here. That provision broadly allows the court to take jurisdiction where the child is physically present in Massachusetts, which he obviously was at the time of the proceeding, and where it is necessary in an emergency to protect the child from neglect or for other good cause shown.
Mr. Houlihan, do you suggest that both of those provisions apply with equal force, even if there was a pending open case in New Hampshire at the time?
Well, I want to address the question of the pending case in New Hampshire. And I first want to note a fact that I think that Your Honor hinted at during Mother's argument, that being whether this is a change of position by Mother. As I look at the record and at page 9 of her brief, Mother states that DCYF had closed the case in that state as of August 7, 2018. So I don't think that it would be fair to describe that as a pending or open case as the time that this proceeding commenced in September of 2018. I'll also note the disposition of that case. As described in the record, and again, as described in Mother's brief, there was an ex parte order that was vacated as of July 24, 2018, I believe, leaving no order left that would constitute a custody order. So at this point, I'll refer back to the relevant statute here, which is 209B section 1, the definitions. And it describes a custody determination, which it describes as any court order, instruction or judgment, whether temporary or final, providing for the custody of visitation rights with a child. I believe Mother's argument here is referring then to the incorporation of that definition in section 209B section 2E, which mentions a court of another state which has made a custody determination. In this case, the SJC has actually given some insight on what a custody determination is, and that came about in Custody of Brandon, the case site there being 407 Mass 1, in which the court described an order that provides for custody within the meaning of section 1 as one that creates new rights or modifies existing ones. In this case, the record shows that all we have is an order that was vacated, returning everyone to status quo ante. So there were no new rights created or existing ones modified. Does that answer your question, Your Honor?
Yes, it does. Thank you.
Okay. Mother's contrary argument regarding the statutory definition of home state rests on a misinterpretation of that section in the department's view. The relevant section of the MCCJA defines a home state as the place where a child and at least one parent resided for the 6 months immediately preceding commencement of a custody proceeding. And the following section, section 2A, states that home state jurisdiction exists where the forum state, 1, is the child's home state when proceedings commenced, or 2, was the child's home state before their removal by one parent, where another remains in the forum, which I essentially interpret as a kidnapping exception, a parental kidnapping exception. Here, there's no state that fits the bill. The child and both parents undisputedly resided in Massachusetts for at least 1 month prior to the initial hearing in September 2018, which concededly is not long enough to establish the Commonwealth as the child's home state, but it is sufficient to break New Hampshire's sensible past status as the home state. Unless there's any further questions from the jurisdictional question, I'll address some of Mother's evidentiary points as well.
Please.
With respect to Mother's evidentiary arguments, I'll start by emphasizing the bottom line from the department's perspective. Even if this court were to take Mother's view that some or all of the evidence to which she objects was improperly admitted, the trial court's determination would be amply supported in the remaining record. To be clear, the department does not see any error in the trial court's challenged evidentiary decisions. However, even were there such error, it would be harmless for 2 reasons. First, other portions of the record that are not in dispute establish the same points that are now challenged. First, that child suffered from head flattening, that mother and child were the subject of numerous DCF and DCYF reports during the period from January to September of 2018. Mother's frequent travel between New Hampshire and Massachusetts from April to September of 2018, and mother's mental state and frequently erratic outbursts during the relevant period. Second, the 10 challenged findings of fact and 2 challenged conclusions of law constitute only a small part of the court's determination regarding mother's unfitness. In describing the basis for its decision, the trial court pointed to mother's drug dependency, propensity for aggressive or unstable behavior, housing instability, failure to complete psychological or substance abuse counseling, and evident inability to care for child's special needs. The mother has not provided any basis for this court to find that the challenge provisions, portions of the opinion below were undercut the trial court's determination of unfitness on those points. And as adoption of Luke provides, there's no grounds for reversal where the challenge facts, if extricated, would not undermine the court's conclusion. And again, the department does not believe the trial court committed any error in its consideration of those facts. As detailed in the department's brief, we believe the minimal contextual use of 51A reports and permissible use of hearsay in the 51B reports was entirely within the bounds of existing precedent. But for the points, or for the reasons listed above, I would say that that was harmless regardless of any error.
The mother prevented from gathering evidence from New Hampshire?
It's a good question, Your Honor. I'll answer this question and then cede my time to Attorney Sullivan. I know I'm over time here. The department's position is that she was not prevented for a few reasons. First, as I pointed out in the department's brief, the record shows that mother had the opportunity to submit to the trial court an order for signature requesting those records from New Hampshire. In this case, I was unable to find anything in the record indicating that such an order was in fact submitted to the court. Further, even if it were, New Hampshire's compliance with that order would have been purely voluntary from what the statute says. Section 209B, Section 10 says that the court may request that information, but it says may and request. It suggests a high degree of discretion by the other states' courts. Third, as we pointed out in our brief, mother also had the opportunity to request this information from the New Hampshire authorities of her own accord. Again, I'm not aware of any opportunity or of any evidence that she did so in this record. And finally, I would just note the same point again that we highlighted in our brief, which is even if she had obtained the DCYF reports, the use of those reports in this particular decision appears to be entirely contextual, something akin to effect on the listener, where the reason the trial court cited those reports was in order to show that she had in fact been in New Hampshire at certain points in time. It was more of a setting the stage use than anything else. So if she had obtained the DCYF reports, it wouldn't have undercut that conclusion. It would have only in fact supported it by saying, you know, the court concluded there were reports and here in fact are those reports.
Thank you, Mr. Houlihan. We'll hear from the child. You have to unmute yourself, Attorney Sullivan. I wish I had a nickel for every time I've said that over the past year and a half.
Thank you, Your Honor. If it pleases the court, my name is Ann Sullivan and I represent Child in this case. Child asked this court to affirm the lower court's decision terminating parental rights so that he may be freed up for adoption as soon as possible. First, I'd like to point out that the record does support the fact that the case in New Hampshire was closed. If at the record appendix, page 133, in a 51B report, as part of the investigation by DCF, DCF learned that the case was closed on August, I believe, right, Your Honor, thank you. And that's a 51B, that's an admissible fact. So I don't believe there's any question about that, with all due respect. Secondly, I believe that the jurisdiction issue here is fairly straightforward. The applicable law is 209B, and the question is whether this case comes with any of the 4 paragraphs set out in 209B. The definition of home state jurisdiction, which is in 209B1, is to state where the child resided with his parents, a parent or a guardian, for 6 consecutive months prior to the time the case was filed. So what we're really looking at here is the period from September 13th, 2018, when the case was filed, back to March 18th, 6 months prior. And we're looking for the family consecutive months. What the trial court found was that the child and mother moved between Massachusetts and New Hampshire from the time this child was born until until August of 2018, and that the child and mother had no substantial residence in either state from August to September when it was filed. So I feel based on these facts, it's clear that Massachusetts didn't have home state jurisdiction, and neither did New Hampshire. Child was moved, as the trial court found, mother and child were moving back and forth during this whole period of time. So we look at whether Massachusetts had default jurisdiction. And here the question is, does another state, again, have home state jurisdiction? Well, neither Massachusetts nor New Hampshire had home state jurisdiction. Then the issues become, is it in the child's best interest that Massachusetts exercise home state jurisdiction? And that is whether there are significant connections for the child in Massachusetts and whether there is substantial evidence in Massachusetts regarding the child's care, treatment, personal relationships, etc. In this case, there are significant connections. First with mother and father, both parents grew up here, both parents went to school here, parents met here, parents lived with paternal grandmother from 2016 to 2017. Both paternal grandmother and maternal grandmother lived in Massachusetts. As far as the child went, his family is in Massachusetts. His pre-adoptive mother is here, who was a woman that father knew in Massachusetts since he was a young child and considered his stepmother. And also child gets services here. There is substantial evidence regarding those services, regarding the care he is getting. All his collaterals are here. Based on the facts of this case, it's clear that child does have those significant connections here, and parents do, and also that there are the substantial evidence here. Those two things constitute that was in the best interest of the child for the court to exercise jurisdiction. On the issue of the records, the mother asserted in her brief that the court should have received those, asked for them under section 10B of, section 10A of chapter 209B. Well, first of all, that particular statute doesn't apply. That statute applies for the court to ask the other jurisdiction to hold a hearing or to adduce evidence or to investigate a case. It's not the statute that the court would have used. It's also a discretionary statute. Under chapter 209, section 7, the court could have asked for records. However, the mother says it was clear legal error that the court didn't do so. That's not correct. It's discretion. It's within the court's discretion whether or not it asked for those records. And I concur with my brother's analysis of this case that, first of all, those records, mother had other ways of getting those records. She could have got them under the New Hampshire statute. Also, it's unclear to me how those records would have helped mother at any rate. When you look at this case, Your Honors, when child was in Massachusetts, when the case was filed, what had happened? A 51A had been filed in August. DCF had made a home visit. At that home visit, mother told DCF that she had lived in a trap house, a drug house with the child. Mother was sleeping on a couch. There were concerns about her drug use based on what the allegations, and she really somewhat confirmed those. Child was sleeping in a park and play, what I believe is a car seat. Based on those facts alone, the 51A was substantiated. And essentially it was those concerns, and mother also escalated at that home visit, right? She went from crying to being ebullient, and she was all over the place. The petition was filed based on mother's mental health, concerns about her drug use, the condition of the child, her care of the child. All those facts essentially were what DCF was investigating based on what they knew about what was happening in Massachusetts when they saw the child. I really believe that the jurisdictional issue here is a red herring, and that But aside from that, I assert that the state had, the trial court had default jurisdiction in this case. I also concur with my brother's presentation, and that what mother was objecting to was, I believe it was 10 findings of fact out of 140 and 2 conclusions of law out of 33 conclusions of law. Even if the court were to agree with mother on her objections, and I've gone through each fact and each objection in my brief and said why I believe mother's wrong in her objections, but even if the court were to agree with that, there's overwhelming evidence that mother was unfit to parent child, that she did not benefit from any treatment, that the woman who DCF visited in August of 2018 was the same person, had not addressed her parental deficits when the trial was held.
Sullivan, I think we're going to have to leave it there.
Right.
Thank you very much.
If I just may say, Your Honor, I would ask that that the lower court be upheld, but if the court is concerned about the jurisdictional issue, that the court retain jurisdiction of this case and request that New Hampshire clarify the issue and, if necessary, decline jurisdiction. Thank you, Your Honor.
Thank you. That concludes the hearing in this matter.
We are live and on the record.
Thank you, Flannery. The final case on our list for hearing this morning is case number 2020 P1172, Emmanuel N. Papanikolaou and another versus Farm Avenue, 2 Lots LLC and others. Mr. Harding, you may begin.
Good afternoon, Your Honors. John Harding for the plaintiff and appellants, Emmanuel Papanikolaou and Rose Papanikolaou, as they are the trustees of the Telecom Park Trust. Our position is a very simple one. This case, the decision of the land court judge should be reversed and the case reinstated to the docket to proceed with discovery and further proceedings. The fundamental error we claim here is that the judge misapplied the Iannuccino and Twombly standards for Rule 12b-6 to the circumstances of this matter, which involves a claim that an easement was abandoned. The easement was created in 1971, not by a deed, but by an order of taking of the Commonwealth of Massachusetts in connection with the reconfiguration and modernization of I-95 in Peabody, which is where the properties involved in this case are located. At that time, the property that had the benefit of the easement was owned by the Salem Country Club. It ultimately sold off a small piece of its property, which is the one known as the 27R parcel, in 1994. And then after another 20-year period, that parcel was sold to the present owners, Farm 2 Lots and Mr. Weiss. The error that we're claiming here is that the judge impermissibly expanded the standard of what has to be included in a complaint when you're claiming abandonment of an easement. The central element that must be alleged, and this is clear under all the cases, is that there was an intent by the beneficiary or the dominant estate to abandon the easement. And we allege that. And we just didn't allege it in a conclusory way, but we alleged very specific and compelling facts that this easement, which stated essentially in its entirety that the only purpose was to permit the dominant estate to construct a road over the parcel owned by Papanikolaou and to use it for auxiliary utilities services, was not used for some 33 years.
Mr. Harding, if I may, you are of course familiar with the law that suggests that mere non-use does not constitute abandonment.
Absolutely. And the
And
point that
you
we're,
referred a moment ago to facts that you included, factual allegations that you included among your allegations that evidenced an intent to abandon. Other than non-use, what are those specific facts that you alleged in the complaint?
we did not allege specific facts. That is part of our point. And the point that we're making here is that there's a difference between the pleading standard and the standard required to either support or oppose a motion for summary judgment or to succeed at trial. And all of the cases.
I understand that, but I thought I understood you to say just before I interjected that you had included among your allegations specific facts that supported the allegation of intent.
The specific facts are that the Salem Country Club and then the successor owners each and every day for some 43 years never used the easement, never constructed a road, never used it for utilities. Those are specific facts, and they're
those
compelling
are specific facts
facts
that are confined to non-use, but I understand that they are specific facts.
So then, Mr. Harding, are you relying on paragraph 51 of the complaint where after listing the non-use elements or non-use allegations, the complaint says based on the foregoing and other acts and failures to act reflecting its intention, the country club manifested its intention to abandon. Is that the language that you are arguing is sufficient under Iannuccino?
Yes, exactly. We did not lay out specific itemized additional facts. And we don't think under Iannuccino, which very specifically says that detailed facts are not necessary. Right. Iannuccino derives from Twombly, which says detailed facts are not required. And in fact, the central purpose of discovery is to reveal the facts that are essential for the party to ultimately make out their cause of action. And this
there are certain causes of action that require.
Sorry.
Go ahead, Judge Hand.
All three of us. Sorry about that. My question to you, Mr. Harding, is doesn't Iannuccino, though, raise the bar from just notice pleading and just saying the right things will be manifested in good time to requiring that there be a plausible suggestion? How can an unspecified, in any way, act in failure plausibly suggest an entitlement to recovery?
The plausible suggestion is that 43 years of continuous non-use of this easement, failure to construct a road, is certainly, all the cases recognize, is substantial evidence of abandonment. It is not a mere conclusion. These are the facts and they are not contested. And the restatement of property says that the longer the non-use continues, and it, of course, all of the cases say it's to be based on the specific facts and circumstances. All these cases are unique. They're really, it's hard to draw anything specific from them in terms of requirements. But again, this goes to the evidence that would have to be presented at the conclusion of discovery to either support or oppose a motion for summary judgment or at trial. And all of the Massachusetts cases that we cite, that the land court judge cited, that Mr. Bacino's clients cite, all deal with circumstances as to whether the party met their burden of proof on summary judgment or at trial. We could not locate a single case where a land court judge or any appellate judge indicated that a pleading was not sufficient because it did not lay out with specificity details in addition to the non-use.
Mr. Hardy, let me ask you a question in a somewhat different fashion. If the evidence at trial consisted solely of the facts that are alleged in the complaint, would a rational finder of fact, accepting all of those facts as true, be justified as a matter of law in determining that there was an intent to abandon?
If all we have is we don't dispute that if all we have is the non-use for 43 years, that is not sufficient. That we need additional facts to make our case at trial, and we needed an opportunity to get those.
So going back to Judge Hand's point about the increment by which Iannaquino raised the bar, the allegations of the complaint need plausibly to suggest an entitlement to relief. And I guess my question to you, you keep referring to the need for discovery. What is it? Give me an example, if you would, of a specific element of fact that would be discovered during the discovery process that would entitle you to relief.
What we would be looking for are actions. Let me go back just a second, because all of the cases deal with, in an abandonment situation, it's basically a unilateral act of the beneficiary of the dominant estate.
Right. So we're talking, I mean, in a prior life, I had some involvement with some of these cases.
Absolutely.
You're talking about actions. Sometimes they can include words, but they are actions on the ground, on the site. And why would those not have been visible to to all concerned at the time and available for presentation as part of the complaint?
That's the other point that we depart ways with the land court judge, because she essentially ruled, and this was evident at the statements on the record at the hearing before her decision, that she was saying that only physical changes on the ground, such as erecting a fence, a stone wall, could count. And when you look back at the cases, that whole standard is quite malleable, because in I believe it was the LaSalle case, you dealt with relying on that cars were parked. Well, cars are easily movable, and yet that was held to, the acquiescence in cars blocking was held to be sufficient. But our point is that there can be statements of intent. The cases refer to, was there a statement of a present intention to relinquish rights in the easement? And there could certainly be witnesses from going back to the Salem Country Club or to the other prior owner, where they, at a point in the history, the life of this easement, made statements to that effect. So that is certainly one specific thing.
But you have no present awareness or good faith belief in the existence of any of those statements. That is, to use the vernacular, that sounds like a fishing expedition.
Well, they are non-parties. They are not parties to this case. They're no longer parties to owners of the property.
What is the scope of discovery that you have in mind? I mean, where are you going to go to find these people?
Through the record. I mean, the Salem Country Club is a Massachusetts corporation. They've got board meeting minutes. And so it's a very simple task to be able to subpoena them.
You're going to find a statement in a board meeting where the board of directors of the country club said, you know what, we don't need that easement anymore. We're going to abandon it, but we're not going to tell anybody outside of this meeting.
Yes, that's one example that we think is logical, because there's no stated, the original easement in 1971, it was carved out by the state, but there's nothing we've seen indicating that there was ever a practical purpose for this easement.
But that reality exists independently of any discussion at a board meeting. And if you want to make that argument, you can make it on the basis. This goes back to my original question about the facts that you actually have available, as opposed to those that you imagine might materialize if you happen to strike pay dirt.
Right. I'm not sure what your question is, Your Honor.
My question is, every time you respond to the questions, you are identifying the possibility that something that you don't know about could appear through discovery, but in response to why that might appear, you refer to what you have in the complaint, which is simple non-use.
Right, that is correct. We don't have access to these people without the subpoena power, which is exactly what we wanted to do from the start of the case. And we're instantly shut down by the judge and not allowed to proceed. But again, we don't think this is a matter of pleading. This is what we have to show going forward at summary judgment, at trial, but it's not a pleading issue because there's a difference between stating the elements. And if we had just stated the Salem Country Club intended to abandon, full stop, that would not be sufficient because that is not a fact. That is a mere conclusion. Here we have all three prior owners of this property not is objectively demonstrable that they did not ever enter onto this parcel to construct a roadway or easements. And that's the distinction we're making, is that at the pleading stage, it was inappropriate to cut us off and not give us an opportunity to develop additional facts to make out our case. The non-use is a significant, even though it's a negative sort of fact, it's significant that for 43 years, none of these entities that own this property ever constructed a road over it, even though particularly once the parcel was broken off in 1994, it was essentially a landlocked parcel that had no access to a public way. Whereas before, it was part of, contiguous with the Salem Country Club's property, who always used the Forest Street entrance and exit. But from 1994 through 2014, that was a 20-year period when the owners who did not have any street access, any direct street access from this parcel, did not construct a road as permitted by the easement. So
Could I just ask you, sorry, there's a bit of a delay, but could I just ask you regarding your point about the judge's dismissal of your complaint while declaring that the easement has not been extinguished and that the impact on you?
I'm sorry, were you finished?
Yes.
Yes. So essentially what we're saying there is that, once it's dismissed, the other side, the Farm 2 lots, did not move for any kind of affirmative declaration of relief. I think from our perspective, it was a rather gratuitous action by the judge, because if our complaint is dismissed, then in effect, the property rights stand as they were before the time at which we brought our complaint. So in some sense, I agree that it doesn't directly impact our rights but it was an affirmative declaration. And, essentially it's a fact finding with respect to a complaint that's being dismissed. So that was our point on that.
Thank you. Attorney Pacino.
My time's up, so thank you very much, Your Honors.
Thank you. Good afternoon, Your Honors. Amato Bocchino for the defendant appellee, Farm Avenue 2 Lots LLC, as trustee of the Farm Avenue 2 Lots Realty Trust. I will refer to as 2 Lots. It's a mouthful. Your Honors, case law is clear that non-use of an easement, no matter for how long, does not amount to abandonment of the easement. I think the SJC has relatively recently recognized that in the Cater case cited in 2 Lots brief, that 98 years, which was not enough. And here we're dealing with 43 years at best. Other than that, Your Honors, 2 Lots will rest on its brief. One point. With regard to the judge's dismissal of the claim with prejudice, as well as to declare the rights against the plaintiffs, I think that's a difference without a distinction, because either way it ends up in the same result, that the easement remains to be valid. And other than that, Your Honor, I rest on my two lots brief.
Attorney Bacchino, there are some causes of action that are required under our rules to be pleaded with particularity.
Yes.
Is this one of those?
No. This is not a fraud case, fraud action.
So the question of intent is not determined by non-use alone, but it can, in context, be inferred from non-use in all of the circumstances, right?
Your Honor, I believe evidence of intent has to be affirmed by affirmative or deliberate conduct, not just all of the circumstances. Or else that leads to
acquiescence in conditions that preclude exercise of the easement rights counts for that purpose, right?
I do not believe so, Your Honor. I believe the case law is even non-use, non-needing to use, and even allowing a right-of-way easement to become impassable is not non-use.
Well, impassable, but allowing a building, for example, to be built on it without objection for a period that falls short of the prescriptive period.
Yes, that could be evidence of intent, Your Honor, but a building, of course, is about as about deliberate as you can get in
well, no, but I'm talking about it's the Serbian estate owner that's putting the building up, and the dominant easement holder that's acquiescing in the presence of that building without objection.
Yes, that can be evidence, but again, building is somebody.
I understand. I'm just trying. I'm starting at one end of the spectrum and moving backwards. So now we get into the question of what other circumstances on the ground over the period of non-use might contribute to a finding of intent to abandon.
I think, Your Honor, physical manifestations on the ground, walls, buildings, fences, gates, things of that nature.
Bodies of water?
No, if they're naturally occurring or if they naturally arise, properties flood, no. If one of the property owners, whether it's the Serbian estate owner or the dominant estate owner, if they flood the land, if they turn on the water and make it unusable on purpose, that I think might be intent.
Brush pile?
If one of them placed it on and allowed it to be there, perhaps. There's no but there's no allegations that anybody put any brush piles on this easement, Your Honor.
Well, again, that gets us into a more detailed, granular level of pleading. Quite apart from the question of what would be unearthed during discovery, the question of what needs to be in a complaint in order to provide a plausible claim. I mean, the facts, the cases rather, are rather abundant with statements that very long periods of non-use are a factor in determining intent, right?
Non-use by itself is not a factor.
Non-use by itself is not sufficient, but it is a factor in evaluating intent.
Correct. And those other factors need to be deliberate or affirmative conduct.
Right.
For example, if there's a tree in the middle of a paper street and that tree grew naturally, it was not planted by either estate owner, that is not a factor. Plus, with regard, Your Honor, specifically here with regard to neglect, let's say, allowing it to become impassable, this easement was not a garden variety general access easement. It was for a specific purpose. Come in at any time and build a road and then use it. So none of the prior property owners could be culpable of not going in and clearing the road or cutting down trees or whatever has it, because it was not their right to waive. It was not they could not manifest an intent to abandon that right because they did not have it. They had the right only to come in at any time to build the road, which they did. Well, the current owner did.
I have no further questions. Anything from the panel? Anything more from you, Attorney Bacchino?
No, Your Honors.